China has become increasingly important, not only in terms of the U.S. and other nations having to protect their IP, but creating an environment where IP can be created and used effectively. This panel is going to look at some of the issues that China's facing, that we're facing, and which direction things are going. And for that, we have a trade secret expert and ex-Deputy Director General of WIPO, World IP Organization, Jim Pooley, who's going to moderate. And we have remote panelists from Washington, like Laurie Self, they're at Leadership IP. And Jerry Liu is in Stanford, I believe, or Palo Alto or nearby. He's with Stanford. Jim, take it away.
Oh, thank you. Thank you, Bruce. Yes, we're very fortunate to have today some folks that all of you will recognize here from Berkeley. I'm sorry. Oh, okay. We have Bo Heiden, and next to him we have David Teece, and then from that other school down the peninsula is Jerry Liu. No, it's wonderful to have all of you here, regardless where you are or where you're from. Unfortunately, Mark Cohen could not be with us today, but that's because he has a family emergency that he's attending to. But that will just give these other participants a little more time to talk about a very important issue, as Bruce has indicated. It's quite a bit more controversial now, it seems, than in the past, probably for a number of geopolitical reasons. I mean, just to give a little note on this, I mean, I have great admiration for and respect for China and the Chinese people. I have represented the Chinese government in the past, and so it was a little unusual. Yesterday I was in a court hearing about a protective order in a case where we had asked, that involved a Chinese company indirectly, and we had asked for a provision in the protective order that would keep the information that was exchanged in the litigation from going outside the borders of the United States. And the lawyer on the other side called me a xenophobe as a result. So there may be strong feelings that come up in all of this, and one of the issues or aspects of dealing with intellectual property in China on the enforcement side relates to the independence of the judiciary and the concerns that exist around that. I know if Mark were here, he would be talking a lot about the need for transparency and increased transparency so that we know more about what happens with judicial decision making in China. But I'd like to throw this out to the panel, and we're just going to go in the order in which your pictures appear here. So, Bo, why don't you deal with that? Provide us your response on that issue first. And you can put this together with transparency more generally.
Yeah, I can try to link this together, because one of the issues that I wanted to discuss was what I call the patent system with Chinese characteristics, right? And so it's important to question whether a patent system in an autocratic society that has no independent judiciary is really the same patent system, even though we use the same words, we use the same concepts, but in reality, the state can intervene whenever it wants to. So the Chinese patent system must be understood as a political system, not a property rights system as we know it. So that means that almost by design, it's going to have a transparency issue where maybe even it's coordinated. Some things are made transparent for certain purposes and not transparent for others. We have to understand that that's going to be how the game is played. I mean, this doesn't mean that U.S. firms shouldn't patent in China, but they have to be aware of this political dimension in the business in relation to the strategic interests of the CCP. So So for me, this discussion about the transparency or even the quality of Chinese patents is an important issue for people to understand that the system is always going to be used, or the option is always going to be used as a part of the political goals. So it's one thing when people say that there's lots of statistics. I think this is what Mark would say, that there's statistics that foreigners win, but do we see all the cases, right? And do we know? And how do we know if we see all the cases? This is one of the issues I think Mark would have brought up.
Yeah, I mean, and Mark, I'm sure would say that we haven't seen most of the cases. David, do you have any thoughts on this particular issue?
Well, let me just make a few high-level comments, and then I will specifically address China.
Okay.
First of all, in terms of public policy and supporting innovation in our economy, it's useful to think about value creation and value capture. And I think in the past, we've thought that, hey, listen, if you spend money on R&D and you create new great things, that value capture follows automatically, and of course it does not. And intellectual property plays a huge role in value capture. So does access to complementary assets, so does standards, so does timing, and so forth. But we shouldn't underestimate the importance of intellectual property, and particularly in the United States, where sometimes we're weak in those complementary assets. You know, if we're good at invention and the early stage work, which we clearly are, but we're not so good at manufacturing or doing downstream things or providing other complements, then you're deeply compromised as a nation if your competitive advantage is built around things that are hard to protect. I say that because it puts in context the importance of having a global system of intellectual property that is strong and that works. If we don't have a global system that's strong and it works, and the United States is really in deep, deep doo-doo because our creative abilities can be shared by all, but we can't get paid for it. So with that in mind, just a few comments about the United States and about China. Historically, in the United States, at least through the 80s, we prided ourselves, we had a world-class intellectual property system, but considerable damage has been done to that, in my view, particularly through the eBay decision, which reduces the power or the ability to get an injunction. And so when we look out at other countries, it could well be that maybe today it's Germany that is the gold standard. Actually, there is no gold standard, but the closest to the gold standard could be Germany in terms of getting intellectual property protection, particularly in the world of patents. So where does China fit? Well, to build on what Bo was saying, China has many of the accoutrements of a system of intellectual property. When I first visited China in the 80s, it didn't have anything. And in fact, historically, under the old Maoist regime, you got rewarded with a prize, maybe, a very trivial one for an invention. But in fact, the building blocks, many of the building blocks have been put in place, and so it looks superficially like a Western system of intellectual property. Yes, there's trade secrets. Yes, there's patents. And indeed, in recent years, there are some statistics that I think, Bruce, you may have shared at a previous meeting of IPAS, which showed that, well, maybe it was actually easier to get an injunction in China than in the United States, and that patent owners would win more frequently in China than the United States. However, even if they did win, damages were always small, sometimes trivial. But most importantly, and this is to come to the point that Bo was making and that Mark Cohen would certainly make, is you don't know if you're going to win. There's certainly uncertainty in US courts, but there's a political aspect in China that is quite concealed. And you could be pretty confident that if you're in a technology sector that's of great importance to China, the probability you're going to win, if you're not Chinese, against a Chinese company is pretty low. So IP, just like antitrust, is used as part of a general system of industrial development. And you can say, well, maybe that's smart. Maybe that's what every nation state should do. But the problem is when you got the Western world playing by one set of rules and China playing by a different set of rules, then it's considered to be unfair. It's considered to be asymmetric in a way that you don't want to deal. So transparency, actually, I know that's Mark's term, but I would say it's not, yes, it is a lack of transparency, but really what's behind that is government interference. There's no objective court system, there's no system of appeals, there's no transparency because the government doesn't want there to be transparency. If there was transparency, we would be more upset than we are with respect to how you get treated under Chinese intellectual property. So what does that mean? So let me put on my hat. One hat, I'm a professor at the Haas School. Another hat, I'm the executive chairman of the Berkeley Research Group, but I put on a third hat recently, which is a general partner in Pilatus Capital. So I'm, providing funds to a number of startup companies. And I can tell you this is what we have to do. One, steer clear of China, but we know that we're never going to win in the Chinese market. We know we're going to get our intellectual property taken. And so unless we have a trade secret that we can hold back and never share with a partner, you have to give up the Chinese market. On the other hand, Chinese companies operating in our markets don't have to give up the US market. So there's a gross asymmetry there. It's not true in all cases, but it's certainly true in the cases that I'm looking at. Because I've got some background in IP, I approach actually the whole fundraising in a different way because I can guarantee you when I get an investor, a strategic investor from China, they're not interested in the financial returns. They're interested in can they get a relationship with it, which would now enable them to extract the intellectual property. And by the way, in some cases, you may not care too much because you can't access the Chinese market anyway. So maybe you take the financial capital and recognizing that it's going to be misused in China, misused looking through Western eyes. But since you can't sell in that market anyway, you're no worse off. Anyway, the point here is there's a lot of complexities. Yes, there's a lack of transparency, but in my view, there's now sufficient transparency with respect to the lack of transparency that there is a clear course of action if you're a startup company. But sadly, I don't think there's a lot of wisdom in the startup community about this, although there's, I think, growing wisdom amongst the venture capital community. So this is, all a bit of a pity because I think we'd be better off if both countries had strong and transparent systems of intellectual property. And maybe eventually there'll be some mid-course correction, and that's where we will end up. But it's definitely not where we are right now. And that's bad news for the small to mid-scale enterprises in particular, but it's also bad news, I think, for larger companies unless they've got very effective ways to protect their knowledge assets. And I began my talk by saying it's not just about IP, it's also about complementary assets, time to market, and things of that kind. And so if you're a larger company, you're in somewhat better shape than you are if you're a small to mid-sized company, if you're operating in the West, that is. But in each case, you're compromised compared to where you would be if you had a reliable and transparent system of intellectual property.
Great. Thank you, David. Jerry, you want to share your opening thoughts with us?
Yes, I'm a lawyer by training, so I will talk a little bit about the judicial system in China, right? And I will use copyright as example, right? After the Rosie assessment of the Chinese market by my fellow panelists. You know, I will actually go through some technicalities in those markets. It's not going to be big picture, right? So every year, the Chinese Supreme Court issue a judicial report that reviews all the statistics for the past year, right? I look at the statistics for last year. I noticed that somehow copyright cases are 4 times more than trademark cases in quantity, and 13 times more than patent cases, right? And that's quite peculiar, right? We need to take this number with a grain of salt because the case filing system in China is somewhat problematic, right? In United States, for example, take Napster, for example. 21 plaintiffs, right, and million sums were involved in the Napster cases, right, that 20 years ago, right? But we all know this is just one case in the United States, right? But in a recent Chinese dispute, where a website copied more than 7,000 news stories from a newspaper, the court requested the newspaper to file more than 7,000 different cases, right? So essentially, the plaintiff was requested to file separate cases for each work. Right, so it's quite a hustle to actually litigate in China. But in any event, it is still relevant safe to conclude that copyright areas enjoy an unparalleled level of growth in recent years. The number of copyright cases increased 50 year to year, and 2 times faster than trademarks, and more than 20 times faster than patent cases. Remarkably, it appears that in most copyright cases, the plaintiffs are actually domestic copyright owners. They're very aggressive in enforcing their rights in court. First of all, we all know that in many trademark and patent cases, specialized IP courts in Shanghai, Beijing, and Guangzhou are courts of first instance subject to appeal to the Supreme Court IP tribunal, right? That's the current practice for trademark and patent. By contrast, in copyright cases, the IP courts actually appellate courts that have final say. There is a subtle competition between those IP courts in a way similar to circuit splits in the United States. For example, Guangzhou IP court appears to be more pro-copyright than other courts in Beijing and Shanghai. This obviously leaves substantial room for parties to do forum shopping. Second, IP courts are increasingly willing to award substantial damages in copyright cases. Actually, to be fair, not just in copyright cases, in all kinds of IP cases. And under new law, punitive damages up to 5 times of the compensatory damages are now available to all IP rights owners. So that's a very useful tool for IP owners, particularly foreign IP owners. I have seen a number of recent cases where courts award tens of millions of dollars for software, video game, and motion pictures. So there is a recent trend that Chinese courts start to award more substantial damages. Copyright cases can also bring enormous non-monetary benefits to many parties involved, right? The reason is very simple. The reason is that copyright cases often involve celebrities and their popular works, right? Movies, music, right? And the litigation itself, win or lose, can bring public attention and promote profiles for all the parties involved. For example, in a recent case in which a television program recited a personal letter, both plaintiff and defendant are ready to settle, but their lawyers and judges encouraged them to carry on because this case involved a very famous Chinese writer, right? The judges encourage them, don't settle, right? Let's carry on, right? That's quite interesting in China. Yeah. So then, as a conclusive remark for my 5 minutes, I want to briefly comment on the phase 1 U.S.-China trade agreement, right? And to be honest, I'm really disappointed at the agreement, especially from the copyright perspective. The only substantive copyright provision in the trade agreement appears to be the legal prohibition against software piracy, right? But the US and China have agreed to fight software piracy since 1992, 30 years ago, right? 1992, right? After almost 30 years of IP negotiation, we have come full circle to exactly where we started. Does that the lack of copyright provision in the freedom agreement suggest that we have no more important IP issues to deal with in China? Obviously not, right? And for example, although motion pictures is one of the largest copyright industries in the world, Chinese courts have denied copyright protection to a number of audiovisual works in recent cases. But I think, you know, because of the time constraint, I will leave it here and we can come back at a later point. Thank you.
Yeah, thank you, Jiarui. I mean, do you, to any of you, do you believe there's going to be a phase 2?
Not me.
Well, and let me put it another way. I mean, that's an aspect of some kind of cooperation. Are we? Do the U.S. and China compete in the intellectual property space in any way?
So what do you mean by compete, right? And do you mean
Well,
competing in terms of law and regulations, or compete in terms of innovation?
Yeah. So, for example, is it easier to get coverage in certain areas of IP, patent software, for example, in China than in the U.S.? Are there? I've had a number of inside IP counsel tell me that the quality of the examination that they get for their patents in China is superior to what they get from the USPTO. Do you believe there's any sort of competition, or is there something economic behind that difference?
I can pick up on this a bit. It relates to what David said before, especially what I would call this, that you have a competition not just amongst companies, but you have a competition amongst institutions. So I call this kind of U.S. patent system game theory. That's my name for it. So whether you believe that the U.S. patent system is necessary to support innovation in the 21st century, and I suppose everyone here today believes that, but whether you believe it or not, you would still be concerned about the comparative development of the patent system in China, right? You would still be worried that how the patent system operates and how it's evolving in China, and you would be concerned about how Chinese companies are participating in the American system. So there's a need to understand that the potential national competitiveness implications and the differences in the strength and the use of the system between the US and China are very important, right? So for example, as you said, Jim, you know, what does it mean that the China patent system allows greater injunctive relief, allows you to patent computer implemented inventions, allows for utility models? What does that mean for firms operating in China? And if this system facilitates better growth and innovation, you know, does the United States need to see this as something it should respond to? So for example, what if Chinese firms own more patents in the US than US firms, where the Chinese patents are evaluated by the rule of law in the US, but our patents are evaluated through this political system, which is what David talked about. So there's a need to govern the US patent system, not only from this internal US perspective, but also from this geopolitical perspective. And I think that's the competition, right? And I think we see the same thing in competition authorities. You can't just look internally, you have to look and see how countries that you're competing with, how are their institutional structures are changing.
All right, and you know, and since we're talking about competition authorities, what about standards and standard essential patents? Is there, and we've seen anti-suit injunctions coming out of China. Is there, you know, is this part of the grand decoupling and the part of the effort by China to try to set standards on its own terms and withdraw from international approaches to that? What's going on?
Well, I do think it is an effort for China to get leverage over the standard setting process and over royalty rates. But I don't see it as leading to withdrawal. I think it's leading to potential corruption of the system. But if the Western countries all are of one mind, which they weren't, but might well be post-Ukraine, then there's a chance that we can hold it together. What we do know is several things. One, first of all, Chinese industry is very inventive. We cannot deny that. The folks that have done work on the quality of Chinese patents conclude in general, many of them are not of high quality. And likewise, with respect to SEPs, there's plenty of, I think, qualitative evidence that they're not necessarily of high quality, but nevertheless, there is great improvement. And there's no question that Huawei is a major player in developing standards technologies. So and China, of course, has published a plan to actually try and take, quote, control of standards. So we have, in the Western world, a system that is open, that's based on professional bodies and engineers working together. And now you have a strong political element because China has made it clear that they want to try and coerce, if you will, the standard setting process in a way that favors China. Now, what are those ways? Well, one way is to bend it in a way that plays to China's strength. Another way is to set up standards in a way that it enables access to information. So there are privacy issues and things of that kind that can be bent through the way that standards are set. So, I think given that both, if you will, the autocracies and the democracies need some amount of compatibility, I think there's a good chance that one system will prevail, or at least there will be compatibility, but there may well be some differences and some fragmentation around the edges.
I can add a little bit to, go ahead, Jerry, you go ahead.
Yeah, let me add my 50 cents on those two issues. First of all, the quality of patent examination, right? I want to highlight one key difference between the US patent system and the Chinese patent system, right? And this key difference might be the reason why we see some high quality patent examinations in China, right? In China, we actually have three kinds of patents, right? A utility patent, right, for invention, right? Then small patents for utility stuff, right? Small patents, right? Then we have design patents, right? And for inventions, we actually the Chinese examiners actually conduct substantive examination, right? Only for invention patents. For utility, small utility, and for designs, they do not initiate substantive patent examination unless the patents are involved in litigation, right? So at a very late point, right? So they basically grant design and small utility patents without substantive examination, right? So they can focus their resources, attention, time to invention patents. So they have probably better equipped to review invention patents in China. But in the United States, we examine everything, right? We have two patents, right? We have utility patent, design patents, but in any event, we examine everything, right? We examine every application, right? So we have to diversify our resources, time on all the applications, right? So it's something actually we should consider, and maybe the Chinese way is not novel at all, right? It's basically the Chinese people learn from European patent system, right? So I think that's maybe something the American people can learn a little bit about from European and from other parts of the world. This is about patent examination. Second, in terms of anti-suit injunction, right? And this is again, it's quite a game between Europe, United States, and China, right? And we saw anti-suit injunction firstly issued in the United States. Then some people came to Germany, right, and filed for anti-suit injunction. Then somebody else come to China to file application for anti-suit injunction, right? It's a bit, to be honest with you, as a lawyer, I feel it's more about the moral, about publicity. It's a publicity stunt than the actual litigation strategy, right? Because unless the other party has assets in Germany or in China, you won't be able to actually enforce anything in China or Germany anyway, right? And so there's no point applying for anti-suit injunction if the other party, I mean the US party, has no substantial assets in China, right? It doesn't make any sense, right? You won't be able to enforce a Chinese injunction in United States anyway, right? There's no treaty between the two countries, and there's no international conventions about injunctive relief anyway, right? And so I don't know what is the point, but anyway, people spend a lot of money on anti-suit injunction, anti. So it's endless game between the parties. So
Yeah, the end of Comity. But
yeah, exactly. Yeah.
If it ever really existed before, but are we? I want to go back to something that Jerry, you said earlier, and kind of passing, that no, we're not going to get a phase 2 agreement. Are we done with negotiating intellectual property issues between the U.S. and China within the trade system? How are we going to do whatever it is that we have to do to make things work better for actors that operate in both countries?
Yeah. Let me just give my 50 cents first. I think right now I'm not 100% sure about the continuing utility of the TRIPS system, right? WTO basically. The TRIPS agreement basically is a trade-related IP agreement under WTO, right? And we tried, I think United States tried once and received a mixed result from WTO panel about IP issues, right? And then that's it. I think that was almost 10 or 15 years ago, right? That was then, and United States didn't really launch any major complaints against China anymore after that. And based on my information, I feel that United States seems to gradually phase out from the WTO. I would love to hear from David and Bowen if my impression was correct or not.
Yeah, and Mark would have something to say about that too if he were here. But yes, Bowen, David, any thoughts?
I don't have a view on that.
I think this is where we needed Mark, but I think definitely the IP. I think one thing that we agree upon when we discussed before was that
it seems like the U.S. government seems that the U.S. government has decided that the WTO is not going to be a forum for IP protection anymore, right? And it's actually, for example, last time I remember the decision was about criminal enforcement, and the U.S. argued that the criminal threshold in China were too low, right? And the criminal threshold didn't catch all the IP infringement at commercial level, right? In commercial scale, right? That's the argument from United States, right? But United States actually lost badly on this point, and so the panel basically argued that decided that the level of commercial scale needs to be decided based on the economic level in each and every country, right? There's no black letter rule here, right? And if in China, if you don't think 500 infringing copies are not commercial, are not in a commercial scale, and that's your own decision, and we respect that. And after that decision, I think the United States was really intimidated by the WTO panel for those kind of decisions.
Yeah, thanks, Jerry. Yeah, Bo.
You could say, Jim, that even though we have a system within the WTO with TRIPS, we don't necessarily use that. We don't solve IP problems within the IP mechanism. We solve them by sanctions, or so they're trade-related remedies. But we say, well, you can't use any of the software, or no U.S. company can sell chips to these people, or sell machines that make chips, or software that run the machines. And so there are stronger levers and very quick levers that trade people can use. That's, it's much better than trying to go in front of a tribunal and argue whether someone's infringing IP.
Yeah, I agree. But that is from a slightly different angle, though. That's not really for the purpose of IP protection, right? This is basically a technology export control, right, by the United States, right? They decide that we don't want to export certain key technologies to other countries. That's somewhat accommodated within the WTO framework. But again, I don't think the technology control is for IP protection reasons. It's more, it's.
No, but that's my argument, Jerry, is that there's a problem on the IP side, but it's solved on the other side. But they're related to each other, but we don't solve them in the.
Yeah,
So,
exactly.
So the last administration argued about IP theft a lot, but they didn't go through the WTO. They put sanctions on other issues. So it's, you can solve the problem with the left hand with the right hand, right?
I want to go back briefly to something that Jerry mentioned earlier. It's utility models in China, and I'm just wondering, and particularly David, if any of your portfolio companies have had experience with dealing with this large body of unexamined patents that exists out there. Clearly, China has been promoting utility models. They get there's about 1 million of them issued a year, I understand. I mean, does this create a lot of broken glass in the road for companies that are trying to do business in China?
I don't really have enough experience on that, but let's just bear in mind that one of the most sensitive things is trade secrets. And patents are, yes, very critical in some sectors, but we often don't pay as much attention to trade secrets. And there are all kinds of ways in which you can lose your trade secrets in China. And in fact, government policy will, this certainly happened in the automobile industry, in exchange for giving the right to set up a factory or to even get access to land, you would often have to share technology. Now that may have changed a little bit with Tesla because Elon Musk wouldn't go along with that. But I think to understand the whole technology transfer and technology protection issue in China, you have to take into account industrial policies that require you to pay with technology. Now, some companies might be willing to do that. And I think the problem is as much ours as it is China's. I say that because when boards of directors and managers are focused on short-term returns, then you might figure that that's a good payback, but it's not good stewardship for the corporation. So I think a lot of the issues coming up vis-a-vis U.S. and China are of our own making, with stock buybacks and efforts by managers to maximize returns while they're in the CEO's seat. And end up with a big golden parachute. One way to do that is to essentially be willing to go along with those kinds of requirements. So I see the picture in the future being a lot more complex. I think export controls are likely, they're definitely on the agenda. And I think there's also a waking up, at least I hope there's a waking up with respect to the managerial classes and boards of directors with respect to the long-term strategic implications of putting a highly proprietary technology in China and expecting to get trade secret protection.
Well, that's something obviously very near and dear to my heart. But let me ask you, Jerry, do you think there's been any positive effect on trade secret protection in China as a result of the Phase 1 agreement that made a couple of what appeared to be major changes in how the law was structured, the shift in burden of proof, the ability to assert indirect misappropriation, that sort of thing. It looked on the surface of it like there was a great deal of progress moving towards a more effective system of enforcement. What's actually happened?
Yeah, I can report, based on my experience in China, that trade secret cases, the number of secret cases is increasing actually in China. And but surprisingly, again, not between a foreign party and a Chinese party, but between two Chinese parties domestically, basically. And I see a substantial, I don't recall the numbers, but I can give you the hyperlink to the report, right? The number of cases are definitely rising. And I think the shift of the burden of proof is very helpful in those cases. But I have to admit that a big part of those cases are not really civil cases, right? When you talk about shift of burden of proof, we're talking about civil cases, right? But actually in China right now, a substantial number of trade secret cases are criminal cases, right? And basically, former employers report their former employees to the police, right? And some of those cases resulted in substantial imprisonment sentence. And so the deterrence is definitely stronger in China. But again, I think litigation, including civil litigation and criminal litigation, are so far underused by foreign parties. I can understand that they're afraid of they're afraid of the political environment, right? That and the pandemic that definitely doesn't help, right? For example, right now it takes about 3 to 6 months to legalize, notarize documents, evidence in the United States. Most of you probably know that, right? In order to litigate in China, you have to legalize and notarize the foreign evidence generated in a foreign country, right? So then the process, because of the pandemic, because of the semi-shutdown of Chinese embassy in the United States due to the pandemic, then it takes almost forever, 3 to 6 months to prepare all those documents. That's quite a hustle for many foreign IP owners. And I also want to add one thing about. I feel I want to add something about the trade negotiation between the United States and China, right? I think the problem about IP development in China actually come from the trade negotiation, from the trade pressure, particularly from the United States, right? It's always become a bundle of other things, right? So basically, the United States said, you need to protect IP rights better, otherwise I will increase the tariffs, right? The tariff or other taxes, right? So it's become a trade-off between lower tariff and better IP protection, right? That's a strategy for the last 20, 30 years between the United States and China, right? But, I think, these kind of IP agreements, it's easier to enforce in terms of the U.S. obligation, right? So for U.S., you just lower tariff, right? From 3 to 2 or to 1, right? That's very easy for China to enforce those obligations, right? But in terms of the level of IP protection, it's very hard to quantify, right? How do you quantify level of IP protection in China, right? Of course, the Chinese government has been updating their IP laws, but that's law on paper, right? How effectively are those laws enforced in reality? We don't know. I'm not saying they don't actually reinforce the IP enforcement in China, but that's very hard to collect evidence to quantify, right? It's very difficult. And more importantly, I think, it is a bad idea to to make IP rights human rights, basically, right? IP rights are human rights, right? It's better ideas to make human rights a part of a trade bargain, right? Somehow the human rights is unnegotiable, right? Somehow become negotiable, right? And somehow, a lot of Chinese people regard international IP protection as a form of economic imperialism from the United States, right? That's a wrong perception. It's a wrong perception, right? And by removing the human faces, like authors, inventors, from the center of IP protection, and American, the trade negotiation undermines the public respect for IP, which is troubling because effective IP enforcement relies no less than on social norms than on legal deterrents, right? I think bundling IP with trade negotiation is such a bad idea, and we need to find a new way.
Wow, in that regard, if we can look more broadly at where these two countries and these two systems are operating these days, we hear a lot now about the end of history, about the end of globalization, about decoupling. Is there a space here with rising nationalism and so forth? Is there a space for finding ways to cooperate and to improve the actual working of IP systems without running into the problems of the past? What's the way forward? I'm sure each of you has a view on that.
If Mark was here, of course, he would say greater transparency in China. But I think we also need to bear in mind that what IP is about is not just about protecting the inventor, but it's also about protecting the investor. And in as much as each country benefits from investments in R&D and in innovation that are made in each country, in each other's country, that there's actually mutual interest in some sense in a strong system of IP. But I don't think China is there at this point, and maybe in the future it can come around. One could always hope for something better. And I think China is still very much in a catch up and get ahead modality, but if it learns to live with peers, I think we can live with peers, but if China can learn to live with peers rather than sort of want to obtain leadership by hook or by crook, I think the two countries can live together. But Xi Jinping is not, I think, of that mindset. So we have to wait for a different era.
Bo?
Yeah, I think that this decoupling, I use the term strategic decoupling because, full decoupling, if we went back to the Cold War with the Soviet Union, there wasn't very little coupled. We're extremely coupled right now, but I think there'll be strategic decoupling in which areas, in order to maintain this kind of power position. As long as there's a power position where both sides would only hurt themselves by hurting each other, you can kind of maintain this. So there's this phrase that I use that the U.S. has to, maintain peace through strength and innovation. We have to compete in this game as if it, as if we need to compete, not that we're just already on top. And in China, of course, is because it's a autocracy. It's able to play this game strategically in a much different way. So we're used to just letting the rules, we put out property rights and we support contracts and we free market. But for a country that's willing to use that when it's useful and go against it when it's not, it's an extremely skewed competition, right? As David said, no one would be upset if China innovates and creates cures for cancer and all that. That would just be great. But when this becomes a strategic geopolitical battle, it has to be managed in a different way.
I think we all hope for convergence, and I think what we now know is there is not convergence. There is, in fact, divergence. And that has enormous strategic implications for individual business enterprises as well as for nation states. And that's the wrenching that's going on right now, is that I think the US naively was thinking with the WTO and so forth that China would be happy to play in the, if you will, the existing global system and play by those rules. But it's now very, very clear that's not the case. And China, of course, has every right not to play by those rules. But we now have to get smart and say, all right, if they're not going to play by those rules, we're pretty dumb if we keep playing by the system that we've had in the past, which is basically, with globalization, we didn't care where the technology went if we ended up getting cheaper goods in return. It didn't matter all that much. Now it matters a lot because technology leadership drives economic leadership, which also drives national security issues. And so the United States is now, and Europe, because of Ukraine, is doing a paradigm shift as well. And we're all moving into a very different world. It didn't have to be this way, but Xi Jinping and Mr. Putin, he's a small player here, but he's giving clear signals as to what it means when you have democracies facing autocracies, and Mr. Putin is kind of a bit of a proxy in the minds of everybody now for Xi Jinping. So the effect of that is an awakening that the global system, as we knew it, is a thing of the past. It has to be a thing of the past. And we're now trying to figure out what's the new paradigm where we can cooperate and compete in a peaceful and productive way.
Jerry.
And then just one quick thing, Jim. I mean, there's a prisoner's dilemma of
Right.
decoupling, right? If you stay coupled, you have a balance, but if one gets decoupled before another, then you have a power. So it's a...
Well, in China, Xi Jinping has this so-called dual circulation. It's a very old Maoist idea to go for self-sufficiency, and China is going down that road. The United States is thinking about some very modest efforts in that regard, but I think China is strategically more advanced in thinking about its own interests than the United States is. We are got too many other issues, but Ukraine has actually caused a refocusing, and I think this will have implications for trade policy, for intellectual property policy. It really is a major, movement of the of seismic dimensions.
Thank you, gentlemen, and we're just about out of time, so I'm going to let Jerry have the last word, and then we'll wrap up.
So right now, I want to say right now, IP issues are very much politicized, right? Politicized, right? And but again, I know I might sound naive, but I do believe IP rights are fundamental human rights, right? As the Human Rights Declaration states, right? And I think an author in China has more common with an author in the United States than Google, right? For example, right? And I think I'm still a little bit conservatively optimistic. We can authors from China, innovators from China, and innovators from the United States can find common grounds, right? And we at this point, to be honest, we cannot just rely on trade negotiations between government officials, right? And I think we, as human, as innovator, as creator, can find more common grounds among us.
Well, we'll leave it there. Gentlemen, thank you very much. Please join me in thanking our panel.